everyone. I'm Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. As a reminder to everyone, today is not your trial date, and so I do encourage you to speak to your attorneys before speaking on the record this morning, because everything that we say is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present both here in the courtroom with me and at the main jail. For those of you at other facilities, know that these attorneys are available to you by phone. For those of you represented by private counsel, know that your attorneys come here to the courtroom with me and are able to address your cases from here. If your attorney is not in the courtroom when I call your name, you can let me know that, and we will see how we can help facilitate that process for you. However, I ask you not to tell me that you have private counsel unless you or your family have already retained counsel for this specific arrest. You also need to know that in the courtroom with me, I have present attorneys from the State Attorney's Office, as well as representatives from confinement status, pretrial supervision, and the Clerk of Courts. All of these persons are here to help facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at First Appearances if you are here on misdemeanors or municipal ordinance matters, but understand that it's dependent on what is going on with you personally and with your case. For those of you present this morning on felony matters or violations of probation where the judge has already set a no bond hold, know that those cannot be changed or resolved here at First Appearances. Following this morning's hearing, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard before your division judge. As we're getting started this morning, I have one case that's been requested to be called out of turn by the jail, and then I will go to our sign-ins after that. To begin, the case that was requested to be called out of turn is for Kieron Bailey.
He's here, main judge.
Thank you. Good morning, Mr. Bailey. Mr. Bailey, you're before the court this morning on a change of charge. Mr. Linder, I want to make sure that this is correct. The charge was originally aggravated battery with a deadly weapon, and it has been changed to attempted first-degree murder. Is that correct?
That is correct, Judge.
All right.
And I believe Your Honor has had an opportunity to review the original arrest warrant.
Yes.
I would ask that the court make a finding of proof evident or presumption grade for first appearance purposes, that Mr. Bailey be held no bond. I believe Your Honor handled the original first appearance and already made a finding of proof evident presumption grade. I think it's for carjacking.
That's correct.
And ordered him to be held no bond on that count. Among the allegations, I know it's alleged that the victim was shot 7 times.
Correct. All right, Mr. Miller, the defense's response. On Kieron Bailey. He's the last person on our docket. The state is seeking a finding of proof evident presumption grade on the change of charge to attempted first-degree murder.
Judge, other than objecting to the court finding proof evident presumption grade based solely on a hearsay document, I have nothing to add to the conversation at this time.
I have re-reviewed the arrest warrant and probable cause affidavit in this case. Based on the allegations and the information that's been provided to me with regard to this charge, at this time, the court is going to make a preliminary finding of proof evident presumption grade in order that Mr. Bailey be held no bond on this count. That will be without prejudice for him to have the appropriate Arthur hearing before his division judge. I believe there's already an order of no victim contact in this case, so there's no need to reiterate that at this time. Thank you. All right, are there any other cases that the jail's requested to be called out of turn?
Not at main judge.
All right, so now we're gonna go to our sign-ins. I'm just gonna go down the list here, if we have them present at the jail. First up on page 20 is Carlton Richards.
Good morning.
Good morning, counsel, how are you?
Fine. Michael B. Cohen for Mr. Richards, 6400 North Andrews Avenue, Suite 505, Fort Lauderdale.
Thank you, Mr. Cohen. Mr. Romero, do you have Mr. Richards there? He's on page 20.
He's approaching, Judge.
Thank you.
Call.
All right.
Your present, Judge. There's your private attorney right there in the bottom middle.
Good morning, Mr. Richards. You're before the court this morning on one charge of fleeing or attempting to elude law enforcement. I find probable cause for this charge. Your private counsel, Mr. Cohen, is with me in the courtroom.
Yes, Judge, and his family's here too. They retained
Okay.
me this morning to take care of my client.
Thank you.
We have a disposition on release conditions, Your Honor.
Okay, what's that?
Your Honor, if it's acceptable to the court, we've agreed to ROR to pretrial. I spoke with Mr. Cohen this morning. He's advised me that Mr. Richards' family is present, so I've taken that into consideration. Also checked and I saw no criminal history.
Okay. I reviewed the probable cause affidavit.
Thank you,
I think
Judge.
that that's appropriate. So, I'm going to ROR Mr. Richards on this count and release him to standard pretrial supervision. Mr. Richards, you're gonna be able to discuss all of this with Mr. Cohen following today's hearing, but I just want you to understand a couple of things. Though you are going to be released today, you will have to report to pretrial supervision in person. You'll get some information about that before you're released from the jail. Since today is Friday, that means that you will have to report to pretrial supervision by Monday. If you fail to report to them, as I've instructed you, a warrant will be issued for your arrest. Do you understand that, sir?
Go ahead. Yes.
Thank you very much. All right, good luck to you, sir.
Thank you, Mr. Richards. I'll be in touch with you.
Mr. Cohen,
Thank you, ma'am.
Have a good day.
You too.
All right, next on page 8 is Harold Gross. Good
Please
morning,
approach the
counsel.
judge.
Thank you.
Private counsel.
I'm Russell Williams. I'm standing in for David Sobel, who's representing Mr. Gross.
All right, thank you,
I think we
Mr.
have a
Williams.
stipulated resolution, Judge.
Yes, Your Honor, if I may. I spoke with Mr. Sobel yesterday and discussed this. I just want the court to be aware. The alleged victim is present in court. He's represented by counsel. I spoke with counsel this morning. All three parties have discussed this and are in agreement of these bonding conditions. So the agreement, Your Honor, is a $7,500 bond in order of no victim contact. And, Your Honor, we are also agreeing upon a passport surrender. Upon the discussions, we are okay with Mr. Gross surrendering his passport to his attorney of record, David Sobel, by 5:00 p.m. on Monday, is that the 2nd? March 2nd.
Be done
Is
before
that,
Judge.
I just want to be clear about that, because I know we've had this discussion before. That's not going to prevent him from being released.
No, that's why we're saying it has to be done by a certain date.
That's fine. I just want to make sure.
I'll have Mr. Sobel file some type of pleading with the
Okay.
court indicating that the surrender is in his possession.
Okay.
I actually probably going to get it before he does. If they
Okay.
don't live far from me.
That's fine. All right, for the record, I'm going to make a finding of probable cause, and I will approve the agreement of the parties and set the bond at $7,500. If Mr. Gross does post a monetary bond, there will be an order of no victim contact. Mr. Gross, so that you understand the no contact order, with respect to the alleged victim in this case, the no contact order means no being in the same place at the same time as this person. That order also includes no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that, sir? Okay, I see the yes. All right. There's also going to be a requirement that you surrender your passport to your attorney, Mr. Sobel, by 5 p.m. on Monday. Do you understand that?
Yes, I do.
Okay. All right. I just want to make sure before you leave me, make sure that the order says whatever confinement needs it to say,
Yes,
so
I'll
that it
prepare
doesn't
the
cause
order.
any problems since today's Friday. Okay? All right. Thank you very
Thank
much.
you. Thank you, Judge.
The 2019 case, correct?
see on there twice? Where did all my other cases go? I need this one. Oh, here. All right, next up on page 18 is Jeremy West.
Yes, Your Honor. Douglas Rudman on behalf of Jeremy West.
Good morning, Mr. Rudman.
Come on up, sir. Your private attorney.
Your Honor, we have a lot of agreements with the state, but I need to argue for a lesser monetary bond, if that's
Okay, well, let's start with probable cause. Okay? All right, good morning, Mr. West. Mr. West, you're before the court this morning on 3 charges. Count 1, aggravated stalking. Count 2, making a false report concerning the use of a firearm in a violent manner. Count 3 is sending a written threat to kill or injure another. I do find probable cause for these charges. You're,
I just want to address one issue with probable cause.
All right,
just
go ahead.
For record purposes, and I spoke about this with counsel.
all right,
Count 2, and I know this issue's come up before, Your Honor.
yes.
I will concede there's not been an allegation of a false report under
Okay.
790.163.
All right.
I would argue under 790.162 that contained in the affidavit, there was a threat to discharge a destructive device, specifically where it claims that the defendant stated, "I think I'm scared of you. If it was up to me, I'd bomb and kill all you, and I won't complete the sentence."
Okay.
It's still a secondary felony, and it's just, Your Honor, that is the appropriate statute, so I just wanted to
Okay,
address that.
I'll make Mr. Rubin, if there's no objection, I'll just make the correction on my finding sheet.
Your Honor, even if I do object, you're just going to reset it. We'll come back tomorrow. He'll do it on the proper paperwork, and you're going to find it anyway. So why delay the inevitable?
Let me just make that correction then.
You take me out of here. Got it. Fine.
All right, gentlemen. Mr. Linder, what's the state recommending?
Thank you, Your Honor. As far as history, I checked Mr. West. I believe he has a pending DUI. Nothing really more serious than that. That being said, and I've discussed with counsel, I do have great concern for the safety of the victim. I understand, according to the paperwork here, that it does state that she lives in another state. But frankly, with the technology today, I believe if anyone's motivated enough, they can find pretty much where anyone is. And based on these threats, I'm going to be requesting $50,000 bond on each count. I think, and a GPS monitor, no victim contact, no possession of any weapons, firearms, ammunition, or explosive devices, no possession of any devices with internet access. Your Honor, I just believe, one, while a GPS monitor, the monetary bond, I think, is an appropriate deterrent to make sure that he stays away from this woman, that he does not continue to threaten her or her child. If he does not, if he decides not to follow with the court's orders, then the GPS monitor would allow law enforcement to know where he is.
Okay. All right, Mr. Rubin, I'll hear your response.
Your Honor, respectfully to the state, I'll draw your attention to the first page of the booking record. It says my client has lived at his address in Pompano Beach for 444 months, which is a significant period of time. My client, allegedly within the 4 corners of the stock, is a keyboard commando. He puts stuff out there he shouldn't. I would ask that he not be allowed to possess or use any computers or internet device. I think that's going to be one of those things. Judge, the ankle monitor is certainly well within the purview because the court's going to be able to identify where he is. As Your Honor well knows, the primary purpose of bond is threefold. Number 1, to ensure the defendant's appearance in court. Number 2, to protect the victims, as the state points out. And number 3, to protect the integrity of the court at large. Judge, I believe that a $150,000 bond in this case is tantamount to no bond for my client. He does work. Judge, you can tell by the other charge that he has that my client unfortunately enjoys the alcoholic drink a little bit. If you would put no drinks, no alcohol, no illegal drugs, random testing, that's one of the other things that we can fit. What I would implore this court to do, Judge, if you did $10,000 per count for a grand total of $30,000, that is a bond he can make. He can continue to work, and I believe all of the concerns that the state may have as far as his ability to show up to court, the victim being protected because of the real-time GPS monitoring. I believe that these are things that can be satisfied by the bond that I've proposed, Judge.
Okay.
That's why I said we're probably in agreement about 95% of it. I just want him to have the
Okay.
chance to get out.
It's the monetary component.
And I believe the record is this has been going on for over a year. While it may seem like an aggravator, Judge, it also would say, listen, this is something where there's been no attempt to second or carry over or make contact or do anything. It's bad, it's offensive within the four corners of the document, but it only happens when he gets to a particular place, and I'm trying to address those issues pre-trial, so maybe we could fix this.
All right. All right, I'm going to set the bond at $15,000 per count. And if Mr. West does post his monetary bond, he will be placed on pretrial supervision with a level 2 GPS monitor. There will be an order of no victim contact. Mr. West, so that you understand that order, while I understand the victim may reside elsewhere, since you'll be wearing a GPS monitor, that will include a 500-foot stay-away order from this person. So no being in the same place at the same time. The no contact order also includes no phone calls or text messages to this person, no third-party contact or social media contact of any kind with this person. Do you understand that?
I understand, Your Honor.
All right. Additionally, there's going to be an order that you possess no weapons, firearms, or ammunition. That means if you are in possession of any of those items, they are to be surrendered to local law enforcement until further order of the court. Do you understand that?
I understand.
All right. There's also going to be a requirement that you possess no devices with access to the internet until further order of the court. Do you understand?
I understand.
All right. And additionally, per the suggestion of Mr. Rudman, I am going to impose an order that you be subjected to random drug and alcohol testing. That means no alcohol or intoxicants until further order of the court. Do you understand that?
I understand.
All right. Thank you very much, sir. Good luck.
Thank you, Judge.
Thank you, Your Honor.
Level 2 does allow him to work.
That's correct. He
Thank you.
provides his schedule to pretrial.
Thank you, Judge. Have a great day.
Same to you.
Just give me 1 second.
Okay. Next is going to be Morley Watson on page 11.
Good morning, Judge. Jerry McLaurin on behalf of Mr. Watson.
Good morning, Mr.
Please
McLaurin.
approach,
Good,
Judge.
Judge, I do have a probable cause argument.
Time, sir.
Also have a colloquy I want to enter
One
with the court.
moment, Mr. Watson. All right, let's see here. Mr. Watson, you're before the court this morning on 2 misdemeanor capiases. These are related to county ordinance violations. And
Yeah, I just walked across the street, jumped out of the car.
Mr. Watson, just hang on a second, okay?
Yeah.
Your attorney, Mr. McLaurin, is with me in the courtroom. At this time, I would advise you just to listen and let him do his job to speak, all right? Mr. McLaurin, I will hear from you now.
Thank you, Judge. Judge, if I may approach with
Come on up.
Florida Statute 125.69.
And, Your Honor, for the record, the state's objecting. These arrests are based on a capias.
I understand.
Judge, in both notices to appear, the statute that's cited is 125.69. In both situations, the state has filed an instruction to the clerk's office citing 125.69. 125.69, as its title, pertains to code enforcement. In section 1 of 125.69, it talks about, it authorizes the county to be able to prosecute county ordinances. But it doesn't, there's no criminal enforcement portion to that particular statute. There is a county ordinance that deals with this type of situation, but that also does not have a criminal enforcement statute. So I discussed this with Mr. Watson. I told him that I don't think that there's any criminal enforceability here that the state could enforce against him. Nonetheless, he wants to take a plea. It would be against my advice, and I wouldn't want to stand there if he takes a plea to something that's not criminally enforceable. This does not belong in this courtroom. And I would ask the court to release him on his own recognizance.
All right, Mr. Linder.
This is not the proper forum for Mr. McLawrence's argument.
I
He's
want to plead no
essentially-
contest and get out of here.
Mr. Watson, just one moment, please.
Unless he has any evidence that the assigned judge at a West Satellite improperly issued a capias, I think that's really all that can be argued at this point.
Okay, since we are here for the first appearance hearing, I would agree, since this is a capias issue, I am going to make a finding of probable cause, but I'm gonna give Mr. Watson two options. And Mr. McLawrence, if you want a few minutes to talk to him privately on the phone, I'm gonna give you the opportunity. But the two options are going to be either I will ROR him on these, which means that he will have to reappear in court to address them at that time, which would be the more appropriate time to make this argument. Or, you know, if he wants to take a plea offer today, I understand everything that you've said. Ultimately, it will be his decision, but I want to make sure that he understands all of the implications of that.
So Judge, just so the court is aware, before the court took the bench, I was actually in the jail with Mr. Watson, and I
Okay.
spoke to him about it.
All right?
And Judge, it would be against my advice, Judge. He wants to take a plea, but I don't see what he's taking a plea to. There's no criminal statute here. There's no criminal enforcement. He's not. If he took a plea, it would be to something that doesn't exist.
Okay. All right, well, we also have to see if Mr. Watson can make it through the plea colloquy to my satisfaction, so I'm not sure if there's other issues that need to be addressed there, but we'll certainly find out. All right, so Deputy, we turn the speaker on so I can speak to Mr. Watson? All right, Mr. Watson, I want you to understand a couple of things, okay?
Yeah.
Number one, do you understand what Mr. McLawrence has said to me and what he's discussed with you this morning?
Yeah.
All right, I understand that your number one concern is getting out of the jail, okay? I get that. But I'm giving you two options today. Option one, I can release you on your own recognizance, which means that you will get out today, but you will have to return to court on another day to address this issue with your division judge. Mr. McLawrence has made some very well-founded arguments, and you may want to address those. Option two, if you don't want to do that and you want to take a plea, assuming that you understand everything that your attorney has said to you today, that is your decision to make. So do you understand everything I've just said to you?
Yeah. I plead no contest.
All right. All right, so Mr. Watson, I'm going to ask you a few questions and we'll see if you can answer them properly, all right? Will you raise your right hand for me?
Yeah.
Do you swear or affirm to tell the truth?
Yeah.
All right. I guess I should ask before we go any further, what is the offer on this case?
The documented offers of withholding court costs on each case.
Withholding court costs?
Yes, ma'am.
All right. And Mr. Watson, the offer on each of these cases is a withhold of adjudication plus court costs. Do you understand that?
Yeah.
And do you wish to accept that offer today?
Yeah.
All right. Once again, do you understand everything we've discussed here this morning?
Yes, I do.
Is anyone forcing you to resolve this matter?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, guilty or no contest?
No contest.
All right, Mr. Watson, I accept your plea and find that it is freely and voluntarily given. Your sentence as to both matters will be a withhold of adjudication plus court costs. Good luck to you, sir.
I got time, sir?
It's a withhold of adjudication plus court costs.
Yes, you'll get out.
okay.
You'll get out later today, Mr. Watson.
Oh, okay.
All right, thank you. Mr. McLawrence, thank you. Thank you for your efforts. All right.
I'm getting into that. No reason to.
Next up is going to be David Marcus on page 14.
Mr. Marcus, come on up, please.
Morning, Judge. Ken Padwitz on
Your
behalf of
private
Mr. Marcus.
counsel's right there.
Good morning,
bottom.
Mr. Padwitz. Good Good morning, Mr. Marcus. Mr. Marcus, you're before the court this morning on 6 charges. Counts 1 and 2 are each a separate count for trafficking methamphetamine between 28 grams and 200 grams. Count 3, conspiring to traffic a controlled substance. Count 4, trafficking MDMA between 10 and 200 grams. Count 5, possession of cocaine. 6, possession of LSD. I find probable cause for these charges, and your attorney, Mr. Padowitz, is with me in the courtroom. At this time, I will hear from the parties.
Thank you, Judge. My client does have 6 counts on him. If the court read the probable cause affidavit, I think it's 3 or 4 pages. There's nothing in that probable cause affidavit concerning my client except for the last 2 paragraphs of the 3 or 4 page document, and it only has to do with alleged admissions. My client he's indigent, has no money, has no bank accounts. He lives in Plantation, grew up in Plantation, went to American Heritage High School. His parents live in Plantation and be willing to have him live with them if the court was so inclined. Because of my client's lack of resources, he's not a threat to the community. What we're talking about are 3-year minimum mandatories. This is not a 15 or a 25-year minimum mandatory trafficking charges. I would ask the court, based on that the court give him a $5,000 bond on each of the first 4 counts, which are trafficking, conspiring to traffic, and trafficking. And then on the possession of LSD and the possession of cocaine, that the court give him a $1,000 bond, which would amount to an $18,000 bond. I think the court could also place him on pretrial release, put him on level 2, to ensure the court that he's going to be present here for court, which I have no doubt that he will be. But my client does contest the alleged admissions that he's made, and clearly from the probable cause affidavit, the admissions are really only thing that ties him to his roommate's, a co-defendant who has been arrested on these charges, drug trafficking.
Okay. All right, and Mr. Linder?
Your Honor, I would be requesting that the court keep the bonds in place. These do carry 3-year minimum mandatory sentences. I would argue certainly his admissions are strong evidence, but there is also circumstantial evidence to support that. Statements made by his co-arrestee, who he is supplied by Mr. Marcus. It is a cause for concern at a minimum. If you go by what Mr. Marcus is advising law enforcement, he is a middleman, but he is a supplier. He does have a prior for drug trafficking. It was a 2003 trafficking MDMA. He did receive a withhold. I'm showing priors out of the state of Colorado. Harassment in 2013. Assault and battery, 2009. UI in Broward in 06, Your Honor. Nothing further.
Judge, if I could just briefly respond. My understanding is that out of Colorado, these are misdemeanors, and they are quite some time ago. There is a prior trafficking, as the prosecutor indicated, but it is withhold adjudication where we received probation and completed that entire probationary sentence here in Broward County.
All right, I will reduce the monetary bond somewhat. I'm not gonna go as low as 5, but I will make the following reductions. On counts 1 and 2, the bond will be set at $20,000 per count. On counts 3 and 4, the bond will be set at $10,000 per count. And I will leave the $1,000 bonds in place on 5 and 6. If Mr. Marcus does post a monetary bond, he'll be placed on pretrial supervision with a level 2 GPS monitor, and he will be subjected to random drug and alcohol testing. Mr. Marcus, the random testing means no alcohol and no intoxicants until further order of the court. Do you understand that, sir? Okay. All right. Thank you. All right. All right. Thank you. Thank you, gentlemen. Good luck to you, Mr. Marcus.
Thank you, Your Honor.
All right. I think that, okay. All right, next on page 8, Kevin Bianame. He has family present in the courtroom.
North Broward, Judge.
Okay.
Good morning, Your Honor.
Good morning, Deputy.
He's a
Happy
medical
Friday.
reset.
All right. Okay.
Same seat, thank you.
All right. So, ma'am, I just want to let you know, because you came for the hearing this morning, because he's a medical reset, he'll likely be reset to tomorrow morning at the same time in the same place. It means that it could be a number of things. I'm not going to speculate as to what it could be, but if there's some sort of a medical issue or he's not feeling well or there's some reason that he's not appearing this morning, it means that the hearing gets reset to tomorrow. Okay?
Saturday?
Yes. We have first appearances on Saturdays and Sundays. Twice a day, 7 days a week.
Okay.
All right? Thank you very much. So it'll be reset to tomorrow morning, same place, same time. All right, thank you. Okay, I think that's all of our sign-ins. So now I'm going to start with our regular list. First up will be Jennifer Cespedes.
Ada. I'm Ada.
Which facility is she?
All right.
Thank you.
Yeah, you.
All right.
Yeah.
Good morning, Deputy.
Good morning, ma'am.
Good morning.
All right, good morning. Are you Miss Cespedes?
Ferrer.
Yeah.
Okay, wrong one. I need Jennifer Cespedes.
Wait,
We're not to Miss Ferrer yet.
wait, isn't Ms. Ferrer up for a second look this afternoon? Is there a charge?
I'm not sure.
Yes, Your Honor. Jennifer's here, right?
This is Miss Ferrer, but I need Cespedes. Cespedes.
This is you and I.
No.
What's your last name?
Ferrer. Ferrer.
I'm sorry, Your Honor. They sent the wrong person. I'll get back to you.
That's okay, just let me know, Deputy. I'll put it on recall.
Thank you.
Thank you. Shirley Bonito.
She's here, President Judge at Maine, approaching.
Thank you. Good morning, Miss Bonito.
Good morning.
You're before the court this morning on one charge of trespassing on an occupied structure or conveyance. I find probable cause, and I'll hear from the parties.
Judge, after speaking with Ms. Bonito earlier this morning, she wishes to resolve this matter. We want to see if the state had a plea offer for her.
Withholding court costs, no return.
Judge, she wishes up the state's offer.
All right, Ms. Bonito, I'm going to ask you a few questions before we're done for the day. So, to begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
I do.
Thank you. And now you can put your hand down. And Ms. Bonito, do you understand everything we've discussed so far this morning?
Yes.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for a mental or emotional illness?
Yes.
Is there anything about that illness today that impacts your ability to accept this plea?
No.
And do you understand that if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
All right. And Ms. Bonito, what plea do you wish to enter? Guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence will be a withhold of adjudication plus court costs, and there will be a no return order to the location this occurred at. Do you understand that, ma'am?
Yes.
All right, thank you very much. Good luck to you. If that's one of the other facilities, can you have them turn their speaker off, please? All right, and I have our Spanish interpreter present. What cases do we need a Spanish interpreter on?
For one person at Maine, Judge,
Okay,
and his name is Mr. Alberto Acosta.
okay.
Senor Acosta.
What page is he on, Mr. Romero?
21.
All right, and for my interpreter, will you please raise your right hand? Do you swear or affirm to interpret from Spanish to English and English to Spanish to the best of your ability?
I do, for the record, Moises Hernandez.
Thank you, Mr. Hernandez. Good morning, Mr. Acosta.
Buenos días, señora Costa. Good morning.
You're before the court
Está ante el
this
tribunal
morning
en la
on two
mañana de hoy
charges.
por dos cargos, dos acusaciones.
Count one,
El
battery
primer
on an
cargo,
officer.
agresión sobre un agente del orden público.
Count two,
Segundo
disorderly
cargo.
intoxication in a public place causing a disturbance.
Desorden por intoxicado y causar una perturbación pública o alteración a la paz.
I find probable cause,
Encuentro que hay fundamentos para proceder.
and I will hear from the parties.
Escucharé de las partes.
Your Honor, state would be
Su
requesting
señoría, la
$1,000
fiscalía va a solicitar una fianza de $1,000.
Okay. Mr. Romero?
Señor Romero.
Judge, Mr. Acosta gave me the phone number of his sister, who I intend to call after court to post his monetary bond.
Su señoría, el señor Acosta se va a comunicar con la hermana. Yo estaré comunicándome con la hermana del señor Acosta para la fianza.
From what he advised me, he believes that her using the service of bondsman can post her bond, so at this time, nothing from the defense.
De lo que él me indica, él entiende que ella puede usar los servicios de un agente fiador, por lo tanto no hay nada más que mencionar sobre este asunto.
All right, then the bond on count one will be set at $1,000.
Muy bien, pues la fianza por el primer cargo se fijará en la suma de $1,000.
Good luck to you, Mr. Acosta.
Buena suerte, señora Acosta.
Is there anyone else at the main jail that requires a Spanish interpreter?
¿Alguien más en la cárcel principal que requiera de un intérprete de español? Levante la mano.
Not that I'm aware of, Judge.
Okay. Is there anyone at Paul Ryan, Conti, or North Broward that requires a Spanish interpreter?
¿Hay alguien en Paul Ryan o Conti que necesite de un intérprete de español?
All right, Mr. Hernandez, thank you. Happy
Thank you,
Friday.
Judge. Likewise.
Next up will be Stephanie Samuels.
She's here at main, Judge, approaching. Come on up, ma'am.
Good morning, Ms. Samuels.
Good morning.
You're before the court this morning on two misdemeanor capiases. These are related to charges for possession of cannabis and possession of drug paraphernalia. I find probable cause, and I will hear from the parties.
Judge, at this time, and speaking Ms. Samuels, I advise her some of her options, but at this time, she wants me to ask, what is the state's plea offer on these offenses?
Withhold court costs.
Judge, she wishes to accept the state's offer.
All right, Ms. Samuels, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
All right, and now you can put your hand down. Ms. Samuels, do you understand everything that we've discussed so far this morning?
Yes.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that impacts your ability to accept this plea?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
And Ms. Samuels, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. Your sentence will be a withhold of adjudication plus court costs. Good luck to you, ma'am. Maria Medina Fernandez.
Paul Ryan.
And Cespedes is ready in Paul.
Responded, Your Honor.
Okay. All right, so now we'll go, is Cespedes at Paul Ryan? Okay.
Yes, ma'am.
All right, let's take Jennifer Cespedes.
Good morning.
Good morning. Ms. Cespedes, you're before the court this morning on a change of charge. The charge was originally touch or strike battery, domestic violence. It has been changed to battery, second or subsequent offense. Mr. Linder, what was the bond set at before?
It was set at 1,000. I'm sure Judge McHugh was aware of her priors when she set that bond, so
Okay.
I just asked for the 1,000. A new no victim contact order has to be issued, though.
Okay.
Judge, she's never been through magistrate on either charge. She was arraigned yesterday, and they've already filed a speedy demand in her case, so we're on top of this.
Okay, all right, so I'm just going to reset the bond at $1,000 as it was originally set, Mrs. Cespedes. And I'm going to reapply the no victim contact order. I'm sure that Judge McHugh already said this to you, but I'm just gonna repeat it since you're here with me today. The no victim contact order means no being in the same place at the same time as the alleged victim. That includes no phone calls or text messages to that person, and no third-party contact or social media contact. Do you understand that?
Yes, ma'am.
All right, thank you. Good luck to you, ma'am.
Thank you.
Melinda Ventry?
She refused to attend.
Okay, I'll have her reset.
Thank you.
She refused. Lexus Adams? Thank you.
Present, Judge, here on Main.
Thank you. Good morning, Miss Adams. You're before the court this morning on 2 charges. Count 1, first-degree petty theft. Count 2, possession of oxycodone. I find probable cause, and I will hear from the parties. Mr. Romero?
Judge, at this time, Ms. Adams is requesting pretrial release. That's what we'd be asking on her behalf.
Okay.
Your Honor, that's fine. I'd ask for random testing.
All right. I will ROR Miss Adams on count 2. She will be released to pretrial supervision. Miss Adams, a few things I need to advise you of. Number 1, as a condition of your release under pretrial supervision, you will be subjected to random drug and alcohol testing. That means no alcohol, no intoxicants. Do you understand that?
Yes.
All right, there's also going to be an order of no return to the Gap clothing store that's at issue in this case. That means that you're not to go there. Do you understand that?
Yes.
All right, additionally, though you will be released today, you must report to pretrial supervision. Mr. Romero has given you some information there. Since today is Friday, you will have until Monday to report to pretrial. If you fail to report to them, as you have been instructed, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right. Thank you, Miss Adams. Good luck to you. Janae Lloyd. Thank you. Good morning, Miss Lloyd.
Good morning.
Miss Lloyd, you're before the court this morning on 2 charges. Count 1, grand theft between $750 and $5,000. Count 2, obtaining property under $20,000 by fraud. I find probable cause for these charges, and I will hear from the parties at this time.
Judge, I spoke with Ms. Lloyd. She has no objection to the bond that's currently set.
All right, is the state seeking anything further? All right, so then, Ms. Lloyd, I'm gonna leave the standard bonds in place on your case, all right? Good luck to you, ma'am. Dominique Dawkins.
Broward Judge, we have an argument.
All right.
So under the probable cause in this
Hold on.
case, and it appears that
Hold on.
this.
Good morning, Ms. Dawkins.
Good morning.
Ms. Dawkins, you're before the court this morning on 3 charges. Count 1, touch or strike battery. Count 2, child abuse without great bodily harm. Count 3, contributing to the delinquency or dependency of a child. And now, Mr. Miller, I will hear your argument.
So, it appears that this arrest stems from an incident involving what can only be described as a brawl between 4 or 5 different girls.
Right.
I guess school-age children. I don't see where Ms. Dawkins was involved in this altercation. And I don't see where the battery charge comes from. And it appears that they're trying to make the case that she either allowed or encouraged her daughter to participate in this brawl, and that somehow she's being charged with essentially 2 third-degree felonies, or 3 and a misdemeanor. But I don't see how they make the case that she allowed or participated. She knew about it, or according to her Facebook, she knew about it. But I don't see the encouragement or the allowing. It seems like the fight took place away from where she was, and I don't see how she encouraged it. So I'm arguing there's no probable cause to hold her on any of these charges.
Your Honor, it's very clear in the probable cause affidavit. First, a recording shows the defendant encouraging her daughter and Kaylin to fight, even ensuring to the juveniles that Kimora and Jayla would not jump into the one-on-one fight. She's seen nudging another juvenile forward to jump into the fight. She's then no longer in the footage, but she's then seen again actually and intentionally pulling on the hair of another of the victim and striking her in the head 2 times with a closed fist.
All right, based on the probable cause affidavit, go ahead, Mr. Miller. Did you have something else?
Tavia, do you have anything?
I guess I'll have to concede, but it just seems like. So it's my understanding, and Mr. Linder, I'm sure will correct me if I'm wrong, that Ms. Dawkins has never had any contact with law enforcement. We're seeking ROR on all of these charges, or in the alternative pretrial release.
Okay.
Your Honor, I see no history. That being said, though, she was the one adult in this situation. She was supposed to be acting clearly more mature and responsible than the other participants, and she actually got involved in it. I'm requesting, based on the totality of the circumstances, a $2,000 bond on count 2, no victim contact.
Judge, I would just argue that Mr. Linder requesting any bond in this case is merely being punitive. She's not a danger to the community. She's not a flight risk. She's been living here all of her life. There's no benefit to the state to require a bond in this case, and so we're seeking pretrial release.
Your Honor, I know you don't want back and forth, but if Mr. Miller is going to claim that I'm asking for a bond amount to punish Ms. Dawkins, then I think I have a right to defend my request. She's alleged to attack a child. There is a concern.
I understand what the allegations are. They're very serious. I've read everything, taking both the allegations into account, as well as the fact that Ms. Dawkins has no prior history that we are aware of at this time. I am going to ROR her on count 2 and place her on standard pretrial supervision. There will be an order of no victim contact. Ms. Dawkins, a few things that you need to understand. Number 1, with regard to the no victim contact order, that means with respect to the alleged victim in this case, you are not to have any contact with this individual, which I believe is a juvenile. That means no being in the same place at the same time as this person. That means no phone calls or text messages to this person, no third-party contact or social media contact with this person. Do you understand that?
Yes.
Additionally, because I'm placing you on standard pretrial supervision, though you are going to be released today, because today is Friday, you will have until Monday to report to pretrial supervision. If you fail to report to them as I have instructed you, a warrant will be issued for your arrest. Do you understand that?
Yes.
Thank you. Next will be Jasmine Coleman. Good morning, Ms. Coleman.
Good morning.
Ms. Coleman, you're before the court this morning on 2 charges. Count 1, false imprisonment of an adult. Count 2, touch or strike battery. I find probable cause for these charges, and I will hear from the parties at this time.
Your Honor, I'm requesting a $10,000 bond on count 1 and a pretrial release of the GPS monitor. What is so concerning about this case is that this stemmed from a court appearance where Ms. Coleman was appearing before Judge Hurley on a criminal mischief, where the victim in this case is the victim in that case. As she had, it was Ms. Coleman's arraignment. The victim, pursuant to the Florida Constitution, had a right to appear. There were already issues there, as a court deputy had felt it necessary to escort the victim to her car, and that wasn't even enough to protect the victim from Ms. Coleman's actions. If she can't even stay away and not cause harm to this victim outside of a courthouse, I don't know how the court can have confidence that the victim is safe going forward anywhere else.
All right, Mr. Romero.
Judge, I understand the allegations are serious. However, my understanding, I believe that incident happened in December. And since then, I do not believe there's been any further contacts with the alleged victim. I believe the victim is her child's father's girlfriend. My understanding, Judge, Ms. Coleman lives separate and apart from them, has no reason to be around them. She lives in Pompano Beach with her aunt. She is raising her 3-year-old daughter, doesn't get any sort of child support from the child's father. So basically, she's just working to provide for her family. Now, she works at CVS. She's been there employed for about 6 months now, making about $16 an hour. My understanding, Judge, she's been here her whole entire life. She's 28 years old, very strong ties to the community, graduate of Deerfield Beach High School, class of 2010, registered voter in our community. I don't have any, I have no doubts that she'll be appearing in court, based, Judge, on her lack of any significant priors, her strong ties to the community, her lack of financial resources. Judge, I'm respectfully asking for a $1,000 bond on count 1.
I'm not concerned about Ms. Coleman showing up to court. I'm concerned about what she does when she leaves court.
The bond on count 1 will be set at $7,500. I'll leave the standard bond in place on count 2. If Ms. Coleman does post her monetary bond, she will be placed on pretrial supervision with a level 2 GPS monitor. There will also be an order of no victim contact. Ms. Coleman, so that you understand the no contact order with respect to the alleged victim in this case, that means no being in the same place at the same time. Since you'll be wearing a GPS monitor, that will include a 500-foot stay-away order from this person. The no contact order also includes no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that, ma'am?
Yes.
Thank you. All right. Since I have Mr. Plant here, we'll address some of our municipal ordinance cases. First up on page 11 is Kenneth Shepard.
Mr. Shepard, come on up, please. He's approaching, good.
Thank you. Good morning, Mr. Shepard.
Yes, sir.
I'm well. Mr. Shepard, you're before the court this morning on a misdemeanor capias. This is related to a municipal ordinance violation for possession of paraphernalia. I find probable cause. Your attorney, Mr. Plant, is with me in the courtroom. And Mr. Plant, what are we doing with Mr. Shepard's case?
Your Honor, his offer is adjudication with withhold
A withhold of
yeah,
adjudication?
it's a withhold, sorry.
All right, Mr. Shepherd, if you would like to resolve this case today, the city's offer to you is a withhold of adjudication plus court costs. Do you understand that?
Yes,
And do you wish to accept that offer this morning?
yes, ma'am.
All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. And Mr. Shepherd, do you understand everything we've discussed so far this morning?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, Mr. Shepherd? Guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. Your sentence will be a withhold of adjudication plus court costs. Good luck to you, sir.
Good luck, sir.
All right.
Next is William Hennigan on page 12.
Judge, I have a probable cause argument as to count one in this case.
All right,
I know, it's my job.
hold on.
Judge, on page.
Page
Oh,
12,
William-
Mr. Hennigan.
Mr. Hennigan.
Advised he's in regular court.
On what? What is he in court for? Can someone tell me?
I didn't see him.
Seen one of his 30 other.
I've been every.
I know,
William
Mr. Plant,
Hennigan.
if you're with me. Sheila, are you able to tell me where he is?
No, we know him.
You got this look like, who's William Hennigan?
I think he's not confused about who it is. He's confused about why he's not with him in court. Hold on one second. That's probably where he is.
Put it this way, he's got so many MOs that I have to do a more narrow search because they runs out after 2015 cases. Please.
Wait, are you sure that's the correct William Hennigan?
Hold on. No, it's not a different Hennigan. There is only.
Okay.
Yeah.
So confinement is showing that he is in domestic violence court this morning.
And that's what I've been advised by the deputy. They were looking at the computer, they're saying it shows domestic.
Okay.
I don't know why.
Neither do I. All right. Mr. Plant, what do you want
Reset
to
for
do?
the afternoon, Judge.
Yeah. I'll come
All right.
back.
We will reset Mr. Hennigan for the afternoon and we'll find out what's going on.
Thanks, Judge.
Okay, ladies, will you hold this for me for the afternoon? Thank you.
We'll see him then.
Okay, then our last MO case will be Herman Cogdell on page 22. If he's present at the jail. I know he's toward the end of the docket.
Oh, wait, I think, yeah.
Yes, and I have an
Cargill.
argument as to count one,
Okay,
surprisingly enough.
I see him, Judge.
He's approaching, Judge.
okay. Good morning, Mr. Cogdell. Mr. Cogdell, you're before the court this morning on 2 charges. Count 1 is for grand theft auto. Count 2 is a misdemeanor capias related to a municipal ordinance violation for urinating in public. Mr. Miller, I will hear your argument as to
Judge,
count 1.
he's charged with grand theft auto.
Correct.
The PC indicates that the keys were in the car with him, and the car was reported stolen in December.
Yes.
And so I would argue it's too remote in time to connect Mr. Cogdell with the theft of the vehicle. And then there's no reason that he knew, or there's no evidence that he knew or that he should have known that the car was stolen.
Your Honor, there's probable cause. I understand we have this argument. If it goes to trial and the state has to prove beyond a reasonable doubt, I do agree more evidence than this would be required.
And Judge, I would just argue to the court.
Hold on, don't cut him off.
I thought he was done.
Go ahead, Mr. Linder.
Thank you, Judge. But to make an arrest for grand theft auto, I think someone operating a stolen vehicle in possession of that vehicle is enough for an officer to make that arrest.
All right, now you can go, Mr. Miller.
Judge, I would argue that in order for the court to hold someone for any charge, that all of the elements of that charge need to be demonstrated to the court. That inferences and understandings are not enough, that there has to be some evidence that he knew or should have known that this vehicle was stolen. Because it happened 6 weeks prior to his arrest, there's no evidence that he was, had any part in this car being stolen. And so, absent that evidence, I would argue there's no probable cause to hold him on this charge. He still may file it, and he could be required to answer it, but to hold him without all of the evidence before the court today, I think would be improper.
Also noting that there's a different tag than what's assigned to the car, Your Honor, which is circumstantial evidence.
I do see that it appears that the actual tag to the vehicle was in the trunk. All right, for today's purposes, for probable cause, I am going to make a finding of probable cause. If the case goes to trial, if the state decides to file it, then obviously we know that the burden is going to be significantly higher than what we're dealing with today. So in light of the probable cause finding, let me first deal with count one before we deal with the MO. Mr. Romero, I'll hear from you.
Yes, Judge, and speaking of Mr. Cogdell, unfortunately, he's not working. He's right now applying for disability. He's been here his whole entire life. He's 58 years old. He lives in Miami with his sister. From what he advised me, his sister's not going to be able to afford to post his monetary bond. Judge, considering this is a nonviolent offense, there are mitigating circumstances to this case as provided to you by my colleague. I would ask the court to consider releasing Mr. Cogden, either ROR or on ROR2 pretrial release on count one, Judge.
All right, Mr. Linder.
I would have no objection to pretrial pending verification.
All right. And Mr. Plant, that's to count two. Anything you want to tell me?
There's no no argument. Oh, but if he's gonna go to pretrial, then we would,
Have them both go.
yeah.
All right. I will, I'm willing to put Mr. Cogdell, ROR him, and put him on pretrial, but it will be pending verification that he'll be residing with his sister. The reason for that is because I noted the allegations in the probable cause affidavit, the location of where this occurred compared to the fact that you're now telling me that he lives in Miami. I just have some concerns there, and I want to make sure that the address issue checks out. All right, so Mr. Cogdell, so that you understand, if pretrial verifies your address and the information that you provided, then you'll be placed on pretrial supervision. If they are not able to verify that, then the bonds will remain in place as they are. You understand that?
Yes, ma'am.
All right, thank you. Yeah, I'll just put them both on pretrial. Why is there, do you have a problem?
Or RR, is RR better?
It's fine. We can put the MOs on pretrial. It's fine. Let me just ask this, because I was having this issue yesterday. I normally just cross it out and put ROR and then put pending verification. Would you rather me leave that and put pending? Okay.
Which is open to you. So, let me see, case participants.
All right, Mr. Plan, is that all I've got for you this
Yes, sir.
morning?
See you from Mr. Hennigan.
See you this afternoon?
Yes.
Okay. Next up will be Stephen Ralston.
Mr. President, Judge.
Thank you. Good morning, Mr. Ralston.
Morning.
You're before the court this morning on 2 out-of-state felony holds. I find probable cause Count 1 has a no bond hold on it. Mr. Ralston, since these are out of state, they're out of the state of Wyoming, that means that you'll go before the extradition judge in order to address that matter, so you'll likely be in front of her on Tuesday of next week. Good luck to you, sir. Winston Campbell.
Mr. Campbell, come on up, please. He's approaching, Judge.
Okay. Good afternoon, Mr. Campbell, or good morning, excuse me. Mr. Campbell, you're before the court this morning on 5 charges. Count 1, touch or strike battery, domestic violence. 2, criminal mischief between $200 and $1,000. 3 is a felony probation violation, which has a no bond hold. 4, driving with a suspended license, second offense. 5 is for having an expired tag that is not for magistrate. I find probable cause for these charges, and I will hear from the parties as to count 1 at this time.
Your Honor, considering that Mr. Campbell is on probation for attempted murder, and this new offense alleges domestic violence, and he has a previous arrest for domestic violence battery by strangulation and battery that was dropped, I'm requesting a $7,500 bond on count 1, no victim contact.
Judge, considering this is a misdemeanor offense, he's being held no bond on the probation case anyway, Judge. I'm asking on this count for a $2,000 bond on Mr. Campbell's behalf and a photo order as well.
I will sign the photo order. The bond on count 1 will be set at $5,000. There will be an order of no victim contact. Mr. Campbell, so that you understand the no victim contact order, as to the alleged victim in this case, that means no being in the same place at the same time, no phone calls or text messages to this person, and no third-party contact or social media contact with her. Do you understand that?
Yes.
All right, and I do see that you're going to have a hearing with your division judge Monday morning to address the violation of probation. Bernard Lessie.
Sloan, medical?
Okay. Patrick Moylan.
With Broward, Your Honor.
Okay. Good morning, Mr. Moylan.
Good morning.
Mr. Moylan, you're before the court this morning on 2 charges. Count 1, battery, second or subsequent offense, domestic violence. Count 2 is a violation of pretrial release conditions for domestic violence. I find probable cause, and I will hear from the parties.
Your Honor, I'm requesting a $5,000 bond per count, pretrial release of the GPS monitor, no victim contact. Considering the pretrial release condition he's violating is the no contact order that Judge McHugh issued for his father from his pending battery case. He also was arrested in 2017 for domestic violence battery. That also was against his father. That charge was dropped.
All right, Mr. Miller.
Judge, it's likely this charge is going to be dropped as well. According to the probable cause affidavit, the father was not interested in pursuing this. He asked, in fact, he backtracked with his conversation with the police and advised that he could have been hit by a door by accident or something like that. Anyway, the point is,
Hold on, Mr. Moylan.
Mr. Moylan cannot afford the bond is currently set. At $5,000 per count. He's asking for $1,000 total bond. He's a lifetime resident of South Florida. He works with his uncle as a general contractor. He does have a place to stay that is separate and apart from the alleged victim while this is pending and until the case does finally get dropped.
Your Honor, I think the court should be aware, and I'm assuming Mr. Miller didn't see this, the pending case with the no contact order, that was filed February 11th. So I wouldn't necessarily assume that it's going to be dropped or dropped anytime soon.
I understand. And I just want to say, too, for the record, whatever happens with this case, because I understand, Mr. Miller, the statements that you were referring to made by the alleged victim that are referenced in this domestic violence case, or excuse me, in this case that's before us today. But that doesn't change the fact that there was already a no contact order in place, and Mr. Moylan was at the residence with his father where he was not supposed to be. So I just want to make it clear that that's a concern that I have. And Mr. Moylan, let me just say a couple things to you before you speak, okay? Number one, since today is just the first appearance hearing, we're not addressing any of the background or facts of the case. Today, I'm only dealing with bond and release conditions. Do you understand that?
Yes, ma'am.
All right, so is there something you want to tell me that's just about bond or release conditions?
No, no questions.
Okay.
Judge, and I apologize, and I just want to bring some of the court's attention since obviously you're taking into consideration what the victim stated in this case. You should know in the first case, he advised law enforcement at that time that he wasn't sure if he wanted to prosecute due to his fear of being victimized in the future. It also mentions that he's physically disabled.
Okay. All right, I'm going to set the bond on each count at $3,500. If Mr. Moylan does post the monetary bond, he will be placed on pretrial supervision with a level 2 GPS monitor. And there will be another order of no victim contact. Mr. Moylan, I want to advise you that with regard to the no victim contact order, that means with respect to the alleged victim in this case, you are not to be in the same place at the same time as this person. Since you will be wearing a GPS monitor, that will include a 500-foot stay-away order from this person. The no contact order also includes no phone calls or text messages to this person and no third-party contact or social media contact with this person. Do you understand that, sir?
Yes, how do I can't afford $3,500. What do I do?
I'm gonna let you discuss that with your attorney after today's hearing, and if they need to file the appropriate motion, then they'll get more information from you in order to do that, okay?
If I come up with the bond, can I get released today?
If you're able to post the bond, then you will post that, and then pretrial will outfit you with the GPS monitor, and then you'll be released after that.
Okay.
Okay? All right, good luck to you, sir. Next will be Mark Anderson. Okay? Morning, Mr. Anderson.
Morning.
You're before the court this morning on a misdemeanor capias. This is related to a charge for trespassing. I find probable cause. Mr. Romero, what does he want to do?
Judge, Mr. Anderson, when he came up to me, he was really apologetic. He realized he missed court, and he didn't mean to do that. He misplaced the paperwork, Judge. But having said that, Mr. Anderson wishes to resolve this matter today, so we wanted to see if the state had a plea offer for him.
Okay.
The documented offers withhold court costs and no return to 1111 North Ocean Drive in Hollywood.
Judge, he wishes to accept the state's offer.
All right. Mr. Anderson, will you please raise your right hand? Do you swear or affirm to tell the truth?
Whole truth.
Thank you. And
Nothing but the
thank you. And now you can put your hand down. And Mr. Anderson, do you understand everything we've discussed so far this morning?
Yes, ma'am, I do.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Okay. Do you need any more time to speak with your attorney?
Nope.
All right. Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, ma'am.
Okay. Have you ever been treated for mental or emotional illness?
Absolutely not.
All right. And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Understand.
Okay. And Mr. Anderson, what plea do you wish to enter? Guilty or no contest?
No contest.
Okay, I accept your plea and find that it is freely and voluntarily given. Your sentence will be a withhold of adjudication plus court costs, and there will be a no return order to the location that was discussed. Do you understand that?
Can you explain that? I can't explain. I can't pay him. Living on the street.
Judge, first, do you understand what she advised
Yes,
as far as
I did
the
understand.
trespass? Okay. Judge, the issue that he wants to address, Judge, is as far as court costs. My understanding from what he advised me, he doesn't have right now the ability to pay court costs, and that's the issue he would like to speak with the court
I
about.
am looking for a job there.
Okay, so Mr. Anderson, let me tell you this. I usually give people 6 months to pay their court costs. Would 6 months be enough time, or do you need more time than that?
I'm working on getting my ID and my social security card and my birth certificate. I lost everything on the Greyhound bus on the way down here. So.
All right, I tell you what, I'm going to extend the payment period out to 1 year. If you have not been able to get it done in the year, make sure that you communicate that information to the clerk's office, but at least that'll give you the year to get things straight and get on it, okay? All right.
Good luck, sir.
Good luck to you, Mr. Anderson. Thank you. Okay, so his is gonna be a year for his payment. Thank you. Gerardo San Martin,
Mr. San Martin, come on up, please. He's approaching Judge Maine.
thank you.
How you doing, Your Honor?
I'm well. Good morning, Mr. San Martin. You're before the court this morning on a misdemeanor capias. This is related to a charge for battery. I find probable cause. I do see Mr. San Martin has a status hearing scheduled for Monday. In light of that, I'll hear from
I'll
the
see that,
parties.
Judge.
Okay. All right. Does anybody wish to be heard?
Not at this time, Judge.
All right. I'll leave the bond in place. Thank you. Good luck, Mr. San Martin. Aaron Ruddy.
Mr. Reddy, come on up. He's approaching Judge.
Okay.
Good morning.
Good morning, Mr. Ruddy. Here before the court this morning on a misdemeanor capias related to a charge for petty theft. I find probable cause, and I'll hear from the parties.
Judge and speaking, Mr. Reddy, he advised me he wishes to resolve this matter today.
Does the state have an offer?
Yes, Judge.
Okay.
Offer is withhold court cost, no return to the, it's a Home Depot, I just need to get the location.
Okay.
Judge, he wishes to accept the state's offer.
Okay, what's the address?
Thank you. 1951 South State Road 7, West Park.
Okay. All right, Mr. Ruddy, you understand the no return order? You're not to return to the Home Depot?
Yes, Your Honor.
Okay. All right, Mr. Ruddy, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. And now you can put your hand down. And Mr. Ruddy, do you understand everything we've discussed so far this morning?
Yes, Your Honor.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Okay. Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Okay. Have you ever been treated for mental or emotional illness?
No.
All right. And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
All right. And Mr. Ruddy, what plea do you wish to enter? Guilty or no contest?
No contest.
Okay. I accept your plea and find that it's freely and voluntarily given. Your sentence will be a withhold of adjudication plus court costs, and there will be the no return order that we discussed. And you understand that?
Yes, Your Honor.
All right. Good luck to you, Mr. Ruddy. William Simon.
North Broward?
Thank you.
He refused, Your Honor.
Oh, he refused? Okay. Well,
Sorry.
he's got, let me ask this, Mr. Miller, on William Simon's case, he's got a status hearing that's set for Monday. Could you tell
Judge.
me if your office represents him?
We do not represent him, and we can sign him up at the status hearing on Monday.
Okay. All right. Then I'm going to go ahead and make a probable cause finding so he can just go straight to division. Thank you. All right. Next is John Hollis. Good morning, Mr. Hollis. All right. Mr. Hollis, you're before the court this morning on 2 charges. Count 1, resisting an officer obstructing without violence. 2 is for trespassing on property, not a structure or conveyance.
Judge, I spoke with Mr. Hollis this morning.
Okay.
If the court is so inclined, he would like to resolve these charges.
All right. For the record, I find probable cause. And what is the state's offer?
Time served, no return.
Okay. All right, Mr. Hollis, if you would like to Resolve this matter today. The state's offer is an adjudication of guilt with time served, and there will be a no return order to the location this allegedly occurred at. Do you understand that?
Yes, ma'am.
Okay, do you wish to accept that offer today?
Yes, ma'am.
All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. And Mr. Hollis, do you understand everything we've discussed so far this morning?
Yes, ma'am, but this is what I need to know, Joe. Where's my property? They told me they didn't bring it. They didn't let me make a phone call. I need to know where my bike at. I need to know where my tablet at. I know where my
All right,
phone.
let me finish asking you some questions and then we'll find that out, okay? All right, is anyone forcing you to resolve this case?
No, ma'am.
Okay, are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by
Yes,
taking a
ma'am.
plea? Okay? Have you ever been treated for mental or emotional illness?
Yes, ma'am.
Is there anything about that illness today that impacts your
No,
ability
ma'am.
to accept this
No,
plea?
ma'am.
All
No,
right.
ma'am.
And Mr. Hollis, do you understand if you're not a U.S. citizen, taking a plea today
Yes, ma'am.
will subject you to deportation or other immigration changes?
Yes, ma'am.
All right, and what plea do you wish to enter, guilty or no contest?
No contest.
Okay, I accept your plea and find that it's freely and voluntarily given. As we discussed, the sentence will be an adjudication, time served, and there will be a no return order. And you understand the no return order?
Yes, ma'am. But
All
I'm
right.
still asking about
I'm
my
gonna
property.
ask, give me a minute, okay? One thing at a time. All right. Now, can someone please tell me if Mr. Hollis had some personal property that was taken at the time of his arrest, where would that property be located?
The what?
Well, if he had a bicycle, because I know sometimes those are taken to a different location. All right, so, Mr. Hollis, if you had some personal property on you, then the personal property,
I
like,
have my bike. I have my phone, my telephone. I have all
okay.
my medication.
All right, are you
I
gonna
have all that.
listen? Are you gonna listen to me? I'm trying to answer your question. Okay, are you listening?
I'm listening.
Okay. If you have personal property, like a bag or medication, that is probably at the main jail with you. Okay, excuse me, you're at North Broward. It'll probably be at the jail that you're at. If you had a bicycle, then it is probably, since the location of arrest was in Pompano, it would likely be at the BSO Pompano office. All right? Do you understand?
Where's that located?
The deputies there at the jail can give you that address before you're released. All right?
Man,
Good luck to you, sir.
bro, it's that bullshit. I paid $1,000 for a month for that bike.
Sometimes you just can't make people happy.
All right.
Bob Joseph. Thank you. Good morning, Mr. Joseph.
Good morning.
Mr. Joseph, you're before the court this morning on 4 charges. Count 1, resisting an officer obstructing without violence. 2, driving while license suspended, first offense. 3, disobeying a stop or yield sign, that is not for magistrate. And 4 is a civil writ of arrest, which is not for magistrate, but so that you know, the purge amount related to that is $936. I find probable cause. Do the parties wish to be heard on count 2?
Yes, Judge, and speaking to Mr. Joseph, he wanted to see if the state has a plea offer for him to extend on that case today.
It's looking at 10 days.
In that case, no, Judge.
All right, I'll leave it as it is then. All right. Good luck to you, Mr. Joseph. Terrence Welch.
Mr. Welch, come on up, please.
Good morning, Mr. Welch. Mr. Welch, you're before the court this morning on 3 charges. Count 1, resisting an officer obstructing without violence. 2, driving while license suspended. 3 is a misdemeanor capias related to a charge for driving with a suspended license. I find probable cause, and I'll hear from the parties.
The Judge, Mr. Welch is requesting an ROR in these cases.
Well, since he has a capias, that's not gonna happen, so you can give me an alternative request if he has one.
Judge, he wanted to know if the state has a plea offer for him.
I'm showing he pled out a DWS before Judge Powell, November 18th of last year. Pleading out to these two, be 10 days. Specifically on count 2. Obviously, count 3 would be the second.
Probably HTO him also.
I'm sorry?
Would it HTO him also? I don't know what, yeah.
Oh, yeah, there's I can't guarantee, I don't know what
Yeah, I know.
DHSB does,
I
but
was just asking more about the
it could
timeline.
result in that, yeah.
Judge, no thank you at this time.
All right, just so that he knows, he has a status hearing on Monday morning, so he'll be able to see the division judge then. All right, good luck, Mr. Welch. Jordan Jean Baptiste.
Mr. Jean Baptiste, come on up, please.
Good morning, Mr. Jean
Good morning,
Baptiste.
Judge.
Good morning.
Good morning.
Mr. Jean Baptiste, you are before the court this morning on an ad charge. This charge is for tampering in a first-degree felony proceeding. I find probable cause for this charge, and I will hear from the parties.
Your Honor, he's actually was tampering in a punishable by life offense.
Yes.
This offense is punishable by life. The state would be seeking a finding of proof evident or presumption great, and ask that Mr. Jean Baptiste be held no bond on this charge. Obviously, in order of no victim contact. You should read this one.
Mr. Miller.
Yes. Any tampering in a first-degree felony, it goes up one level. So tampering in a first-degree felony is a PBL. Tampering in a PBL offense is also punishable by life.
Well, Judge, I would object to the court finding proof evident presumption great based solely on a hearsay document. That being said, we have nothing else to add to the conversation at this time. We are going to save our fight for another day.
All right. Considering the information that's in the probable cause affidavit, which has specifically taken information from jail calls that are recorded, I am going to make a preliminary finding of proof evident presumption great in order that Mr. Jean Baptiste be held no bond on this charge. That will be without prejudice for him to have the appropriate hearing before his division judge to address that matter. There's also going to be an order of no victim contact, and I just want to clarify that person's initials, which are TS. So, Mr. Jean Baptiste, the no victim contact order means that you're not to have any contact with that person. That means no phone calls or text messages to this person, no third-party contact or social media contact with that person. Do you understand that, sir?
Yes, ma'am.
Thank you. Good luck to you. Franklin DeShiel.
Conti?
Thank you. Good morning, Mr. DeShiel.
Good morning.
Mr. DeShiel, you're before the court this morning on 4 ad charges. Count 4 is robbery without a firearm or weapon. 5, burglary of an occupied structure unarmed. 6, grand theft between $750 and $5,000. 7 is a felony probation violation with a no bond hold. I find probable cause for these charges. I do see, Mr. DeShiel, you're gonna have a hearing with your division judge on Monday morning to address the probation violation. And at this time, I'll hear the parties' recommendations on counts 4 and 5.
Judge, I spoke to Mr. DeShiel this morning. In light of count 7, we're just requesting the court set a reasonable bond.
Okay?
Your Honor, can I have one moment, please? I was not given his paperwork this morning.
Oh, okay, go ahead.
I have it.
It's okay, I just need to check something else. Thank you. Your Honor, in light of the circumstances, and there's no bond hold, I'd be requesting, excuse me, a $2,500 bond on 4, $2,500 bond on 5.
Okay. All right, in light of the no bond hold, I will set the bond on counts 4 and 5 at $2,500. There will also be an order of no return as well as no victim contact. Mr. DeShiel, the no return order as it relates to these charges relates to the racetrack gas station at 3299 North Federal Highway. Do you understand that, sir?
Yes, ma'am.
All right, and you'll be seeing the division judge on Monday morning, as I said, okay?
Okay, thank you.
Good luck to you. Edward McLeod.
Yes, ma'am. How you doing this morning?
Good morning, Mr. McLeod. I'm well, thank you. All right, Mr. McLeod, you're before the court this morning on an ad charge. This is a felony capias related to a charge for operating without a valid license. And, Mr. Linder, I see this has an ROR on it. Is this related to a change of charge?
I think it was just supposed to be no bond attached.
It was a down file, Judge.
Okay, what's going on?
From a driving on a suspended license to a operating without a valid driver's
Okay.
license. He's going to be seeing his judge on Monday for arraignment, so there's really nothing to do here today.
Yeah, and Mr. McLeod has no bond hold, so.
Okay, all right, so I'm gonna leave it as it is. Right now on my paper, it's reading ROR. I'm just gonna leave it that way. And Mr. McLeod, you're gonna have a status hearing with your division judge on Monday morning.
Yes, ma'am.
All right, good luck to you, sir.
Thank you.
Jared Coffer.
Main jail.
Thank you.
One moment, Judge.
Okay.
Judge, I've been advised by the deputies he went to regular court.
He's supposed to have a hearing on Monday. Why is he in court now?
I think he was just on the out-of-state hold.
Oh, he's on the out of state?
Yeah, I mean,
Okay,
No.
what's up?
For us, yes, he's in division because of the DOT.
Oh, okay, so he's in on
yeah,
the
so
DOTs.
I'm sick, yeah.
Okay, that's fine. What I'll do is I'll just make a probable cause finding. That way, if he's addressing the VOPs now, he can just go straight to the extradition judge. Because he's got no bond holds on all of it. Alright, thank you. Jacob Busman.
North Broward.
Thank you. Good morning, Mr.
Hunter, this is the
Busman.
gentleman I spoke to you earlier this morning. His
Yes.
attorney would ask this to be reset for the afternoon.
Okay, did you speak to the attorney?
I did, Your Honor. I spoke to Mr. Busman's attorney, we've agreed on a $5,000 bond,
All right,
no victim contact. Mr. Busman's attorney is aware of the situation. He'll file the appropriate motions. He'll be in contact with Mr. Busman. He cannot be here today. He was in Palm Beach. He was in a lot of traffic, so.
okay, all right. So, Mr. Busman, since I have you here this morning, you are before the court on a charge for aggravated battery causing bodily harm or disability. I find probable cause for that charge, and since your private attorney has spoken with the state attorney, per their agreement, I'm going to approve the agreement since your attorney wasn't able to be here this morning. The bond is going to be set at $5,000, and there's going to be an order of no victim contact. So that you understand the no victim contact order with respect to the alleged victim in this case, that means no being in the same place at the same time as this person. That includes no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that?
Yes, ma'am.
All right, thank you very much. Good luck to you, sir.
All right, thank you.
All right. Hector Leva. Thank you. Good morning, Mr. Leva.
Good morning.
Mr. Leva, you're before the court this morning on one charge of robbery without a firearm or weapon. I find probable cause for this charge, and I will hear from the parties.
One moment, Judge.
Okay.
Your Honor, based on the level of violence in this case, the alleged threat that Mr. Leva was intimating that he was in possession of a weapon, possibly a firearm, Your Honor, the state would be requesting a $7,500 bond and no victim contact.
Okay. Mr. Romero.
Judge, Mr. Leva is not going to be able to quite afford that. What I was going to be asking the court to consider is a $4,000 bond. My understanding, I believe, Mr. Leva, he lives in Palm Beach. He lives with his wife and his four children, his four boys. My understanding is that he pays around $600 a month. Judge, he's 40 years old, been here almost his entire life. He works for New Vision Construction. He's been with that company for 9 years now. He gets paid about $16 an hour. His wife is a stay-at-home mother, taking care of his children, and they rely on Mr. Leva for their financial support. My understanding, Mr. Leva is not a convicted felon. My understanding, he has no prior offenses similar to this judge. He will be coming back to court. He just can't afford what the state is asking for, Judge. He's requesting a $4,000 bond on this case.
Does Mr. Leva have any prior criminal history?
He does, Your Honor, nothing related to this.
Driving, I think, or petty.
All right, the bond will be set at $5,000. There will be an order of no victim contact. Mr. Leva, so that you understand the no victim contact order, that means no being in the same place at the same time as the alleged victim. That includes no phone calls or text messages to this person and no third-party contact or social media contact with this person. Do you understand that, sir?
Yes, Your Honor.
Thank you. Ronald King.
Mr. King, come on up, please.
Good morning, Mr. King.
Mr.
Mr. King, you're before the court this morning on one charge of domestic battery by strangulation in a dating relationship. I find probable cause for this charge, and I will hear from the parties. Okay.
based on the level of violence and allegation of strangulation, and that there was also a threat to kill, I'm going to be requesting a $7,500 bond, no victim contact. I'm showing a 2019 aggravated assault at a Palm Beach that was dropped. Also considering that there is a allegation by the victim that she knows that he owns a gun, at the time of this incident, I'd be requesting no possession of any firearms, weapons, or ammunition.
All right, Mr. Romero?
Judge, as you heard, I believe Mr. King has a clean record. He's been here his whole entire life. He's 24 years old. He was extradited from Palm Beach. I believe he's been in custody now about 5 years. He lives with his parents. His father does work. He's a plumber. Mr. King also does work. He's been working for the same company now for 1 year. It's called Kitchen Art. He basically delivers the cabinets and things of that nature for kitchens. He makes it only about $14 an hour. I believe this non-custody KPS, I believe the date of incident happened last year sometime in 2019. And since then, he's had no further contact with the alleged victim. He will be abiding by that no contact order and will continue to have no contact with that person. But he does not believe his father can afford quite $7,500, so that's why we're requesting a $4,000 bond on Mr. King's behalf, Judge.
The bond's going to be set at $5,000. There's going to be an order of no victim contact, as well as an order that Mr. King possess no weapons, firearms, or ammunition. Mr. King, so that you understand those orders, with respect to the no victim contact order, that means no being in the same place at the same time as the alleged victim. That order includes no phone calls or text messages to this person, no third-party contact or social media contact with this person. Do you understand that?
Yes, Your Honor.
All right. Additionally, with respect to the order that you possess no weapons, firearms, or ammunition, that means if you are in possession of any of those items, they are to be surrendered to local law enforcement until further order of the court. Do you understand that?
No problem.
All right. Thank you very much. Terrence Warner.
Please approach the judge, ma'am.
Thank you.
Judge, at this time, I would like to invoke Mr. Warner's right to remain silent. I would ask that the court order any law enforcement not interview him without the presence of his attorney. Mr. Warner, I would advise you not to discuss your case with anyone, no one in that facility, and especially on the phone.
All right, Mr. Warner, for the record, you're before the court this morning on one charge of first-degree premeditated murder. I find probable cause for this charge, and I will hear from the parties at this time.
Your Honor, the state would be seeking a finding of proof evident or presumption great on this capital offense, and ask that Mr. Warner be held no bond. The court should be aware, and I provided Mr. Miller a copy, though Mr. Warner was arrested on the arrest warrant, the state did obtain an indictment from the grand jury charging Mr. Warner with first-degree premeditated murder, and that was ordered December 19th, 2018.
Your Honor, we're not arguing probable cause today. However, I would object to the court finding proof evident presumption great based solely on an affidavit to arrest. Beyond that, I'm going to reserve any further argument for another day.
I have reviewed the affidavit to arrest in this case. It is quite detailed in the information that it has provided with respect to the present allegations. At this time, the court is going to make a preliminary finding of proof evident presumption great in order that Mr. Warner be held no bond as to this charge. That will be without prejudice for him to have the appropriate Arthur hearing before his division judge to further address these issues. Jerry Lee Grant.
I'm
present, Judge Mayne.
Thank you.
Good morning.
Good morning, Mr. Grant.
Good morning.
Mr. Grant, you're before the court this morning on 9 charges. Counts 1 and 2 are each a separate count for grand theft between $750 and $5,000. Count 3, driving with a suspended license. 4, dealing in stolen property. 5, providing false owner information for pawned items, $300 or more. 6 and 7 are each a separate charge for second-degree petty theft. 8 is grand theft between $750 and $5,000. 9, committing a theft resisting recovery of property. I find probable cause for these charges, and I will hear from the parties at this time.
Judge, Mr. Grant's not going to be able to afford the current bond, which is set, I believe, it's just over $10,000. Now, he's been here his whole entire life. He's 39 years old. Right now, he's looking for work. He lives in Fort Lauderdale with his grandmother. His grandmother's retired. She's on a fixed income, receives Social Security. So he's not in a position to post the full amount right now. What we would be asking the court to consider is on counts 4 and 5. I believe the bonds which are currently in place, the standard bonds, $3,500 on each count. We're going to be requesting that the court could consider lowering it to $1,500 on each count. And also on 6 and 7, the misdemeanor offenses, we were going to be asking the court to consider an ROR on those 2 offenses. So if my math is correct, Judge, I would be asking for a total of $6,000 on Mr. Grant's behalf.
Okay, Mr. Linder?
Your Honor, I'm going to be requesting a $5,000 bond on each of the grand thefts. First off, the court should be aware, at the time of these offenses, Mr. Grant was out on bond for grand theft and hiring with intent to defraud. He since then has picked up another grand theft that is pending. I'm showing, let's see. He has another grand theft that's open right now in Broward from this year. His history includes 2016 unlawful possession of personal identification information, 2016 possession of PVP and loitering and prowling, 2016 theft, 2013 battery. Just checking. Let's see. Grand theft, Palm Beach County, 2018. Grand theft, Palm Beach County, 2019.
How many cases is he out on bond in right now?
Total, from what I could tell, 3 grand thefts.
Judge, my understanding, speaking with Mr. Grant, he did inform me he was out on bond. These offenses, my understanding, Judge, it happened before he was released on bond.
No, Mr. Ramirez's understanding is wrong. On his grand theft and hiring with intent to defraud, Mr. Grant was released May 16th of 2019. I can see at least the first case here occurred November 25th and December 31st of last year. I don't know about the others. Looks like all of them.
All right, rather than revoke his bond sua sponte in the pending cases that have the similar charges to those present today, I am going to increase the bonds on counts 1, 2, and 8 to $5,000 each. And I will leave the other standard bonds in place at this time. There will also be an order of no return that will apply to, I know there are multiple locations at issue in this case. There are multiple Home Depots and I believe one Lowe's store. Mr. Grant, that means that you are not to return to those locations until further order of the court. Do you understand that, sir?
Yes.
Thank you. Curtis Webster.
Mr. Webster, come on up, please.
Good morning, Mr. Webster.
Good morning.
Mr. Webster, you're before the court this morning on 2 charges. Count 1, burglary of an unoccupied conveyance, unarmed. Count 2 is grand theft between $750 and $5,000. I find probable cause for these charges, and I will hear from the parties.
Judge, I was going to ask the court to consider setting a $1,000 bond on count 1 under the third-degree felony, a total $2,000 bond on Mr. Webster's behalf. He's 18 years old, been here his whole life. He just got a job. He works at Williams in Sonoma. He works at the furniture warehouse. He's been there for about 4 months, making $11.50 an hour. He lives in Fort Lauderdale with his father and mother. His father basically works delivering newspapers. That's the person that's going to help post his bond. He's not going to be able to afford very much, and that's why we were requesting a total of $2,000 bond on Mr. Webster's behalf.
Okay.
Your Honor, state's requesting a $7,500 bond on count 1, GPS monitor. He's currently on juvenile probation for burglary of an occupied structure, grand theft auto, resisting without violence, and grand theft.
Bond on count 1 will be set at $3,500. I'll leave the standard bond in place on 2. If Mr. Webster posts his monetary bond, he'll be placed on pretrial supervision with a level 2 GPS monitor. There will also be an order of no return and no victim contact. Mr. Webster, so that you understand the no return and no contact orders, that means that you are not to return to the location that's at issue with relation to these charges. The no victim contact order, whether you know the alleged victim or not, means no being in the same place at the same time as this person, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that, sir?
Yes.
Thank you. Benjamin Flowers.
Approaching, Judge.
Thank you.
And Judge, while he's approaching, can confinement status check to see if his bond's been posted?
We'll check it. It just posted.
Beautiful.
All right, thank you. Yep, I'm finding probable cause. Thank you. Brian LaMadeline.
He's approaching, Judge.
Thank you. Good morning, Mr. LaMadeline.
Morning.
You're before the court this morning on 4 charges. Count 1 is second-degree petty theft, third or subsequent offense. Counts 2, 3, and 4 are each a separate count for a felony probation violation, which have no bond holds. I find probable cause. I do see Mr. LaMadeline is set to go before his division judge on Monday morning to address the VOP issue. In light of that, do the parties wish to be heard on count 1?
No, Judge.
No, Judge.
All right, thank you. Jose Pagan.
Bonded.
Nathaniel Carey.
Bonded.
Damon Raymer.
Morning, Judge. He's here present, Judge, at Maine, and we're going to be waiving formal reading of the charges.
All right. For the record, I do find probable cause, and I will hear from the parties as to bond and release condition recommendations.
Your Honor, the state's requesting a $15,000 bond on counts 2 and count 3. Additional release conditions no contact with minors, pretrial release with a GPS monitor, and no possession of any devices with internet access.
Mr. Romero?
Judge, as far as the state's release conditions, no objection to that at this time. However, in speaking to Mr. Rimmer, he's not going to be able to quite afford the $30,000 which the state has requested. I understand the serious nature of the allegations, but in speaking to Mr. Rimmer, I believe he has a clean record. He's a registered voter here in our community. He's 42 years old, been living here in South Florida since 2001. He works for Team Health. He does medical billing. He's been doing that for 4 years, making about $11 an hour. My understanding is he lives in Sunrise with his significant other. My understanding, Judge, I believe their share is about $600 what they pay in order to stay there. So, Judge, we're going to be requesting about a $5,000 bond on counts 2 and count 3. So we would request a total of $11,000 plus all the other conditions which the state has requested.
Your Honor, I apologize if the court would inquire, where did Mr. Romero say he works?
Where does he work?
Team Health.
Oh, okay.
Can the state confirm whether he has any prior criminal history?
Is that possession of cannabis from 2010?
Is that it?
That's all I see.
The bond on counts 2 and 3 are going to be set at $7,500 each. If Mr. Raymer does post his monetary bond, he will be placed on pretrial release with a level 2 GPS monitor. There will be an order that he not have any contact with any minors. That means no contact with anyone under the age of 18, Mr. Raymer. Do you understand that?
Yes, Your Honor.
Additionally, there will be an order that Mr. Raymer possess no devices with internet access. That includes any type of computer, cell phone, or electronic device, anything that has internet access. I'm not sure, Mr. Romero, based on the fact that you said he works in medical billing, I'm not sure what his specific position is with regard to that workplace, but I want to make it very clear that the order means no devices or equipment with internet access. Do you understand that, Mr. Raymer?
Yes, Your Honor.
Thank you. Next will be Michael Brown.
Mr. Brown, come on up, please.
Good morning, Mr. Brown. You're before the court this morning on one charge of possession of cannabis over 20 grams. I find probable cause, and I'll hear from the parties if they wish to be heard.
Yes, Judge. Unfortunately, Mr. Brown is not going to be able to afford to post the $1,000 bond on this felony possession of cannabis case. He lives in Lauderhill with his mother. She is on Social Security. Right now, Mr. Brown is looking for employment, but financially can't afford anything. That's why he's requesting on this cannabis offense to be released on pretrial release.
Hector, pick up the phone, please.
Your Honor, just to bring to the court's attention, 2004, Mr. Brown was convicted of 2 counts of robbery with a firearm or deadly weapon. In a separate case in '04, he was convicted of burglary of a dwelling. He was sentenced in 2005 to 15 years in Florida State Prison. He was released from state prison September 14th, 2018.
Judge, it's come to my attention, and I didn't know this, Mr. Brown didn't tell me this, but he self-surrendered on this case.
That's correct.
I was unaware.
I assumed. That's okay. All right, based on the circumstances that, led to the arrest, I'm not sure if maybe there are some other issues that need to be addressed with Mr. Brown. I understand. Okay. In light of the circumstances, at this time, I am going to leave the $1,000 bond in place.
Yeah. I mean, it's not up.
Judge, in the meantime, would the court sign an order requesting Mr. Brown participate in the SAP program?
Absolutely. I will do that. Thank you. Good luck to you, Mr. Brown. Next will be Rajiar Alexander.
He's approaching, Judge.
Thank you.
Yeah.
Good morning, Mr. Alexander.
Good morning.
You're before the court this morning on one charge for possession of cocaine. I find probable cause, and I'll hear from the parties.
Judge, nothing to request from the defense.
Okay, anything further from the state?
No, Judge.
All right, I will leave the standard bond in place. Thank you. Steve Miklos.
He spoke with Mr. Miller this morning, Your Honor, and decided he didn't want to attend.
I did speak with Mr. Miller,
Okay.
Mr. Miklos.
Yes?
He asked if I could please waive his appearance.
All right.
He is a client of the Public Defender's Office, and he's not planning to bond out, so we're not gonna object to whatever the state wants.
Okay. For the record, I've already made a probable cause finding in this case, so I will waive his appearance based on what you've told me. Mr. Linder, what's the state requesting?
And Your Honor, I understand what Mr. Miller's saying, and I'm not trying to drag this out. Detective Copley spoke to me about this case. He had some concerns. He just wanted me to advise the court of the victims in this case. Detective Copley's concerned about the safety risks with Mr. Miklos. The victims have safety concerns. It's based on these allegations and Mr. Miklos' history, which includes a 2010 attempted strong-arm robbery. He was sentenced to 7 years state prison. A 2010 home invasion robbery, grand theft of a firearm, 7 years state prison. He has other priors involving dangerous offenses. Those are the most recent.
All right.
With respect to the PBL, Your Honor, the state would be seeking a finding of proof evident or presumption grade on, if I can find the right charge number.
6.
Is this, thank you, Judge, on count 6.
All right.
If the court is inclined to hold him no bond on that count upon a finding, then I would just be making monetary requests for the other amounts. And those would be $25,000 on count 1, $50,000 on count 4, $50,000 on count 5. Your Honor, I can advise the court when Detective Copley's been advised. There's been some different reports. The victim definitely suffered a compound fracture of his leg, but he has received reports that the reason the victim needed so many stitches in his head is because when he was knocked down, Mr. Miklas proceeded to back the car up over the victim and hit his head.
All right. Based on the information that's been provided in the probable cause affidavit, at this time, the court will make a preliminary finding of proof evident presumption great in order that Mr. Miklas be held no bond on count 6. That will be without prejudice for him to have the appropriate Arthur hearing before his division judge. Mr. Linder, I think if I heard your recommendations correctly, you said 25,000 for count 1 and then 50,000 for 4 and 5. Did you make a recommendation on count 2?
I'm sorry, Your Honor. It would 5,000 on 2.
All right. Okay, based on the information that Mr. Miller has provided me as well this morning, I will grant the state's request. The bond on count 1 will be set at $25,000. The bond on count 2 will be set at $5,000. The bonds on counts 4 and 5 will be set at $50,000 each. And I realize that Mr. Miklas isn't here today, but there will be an order of no victim contact. All right. Thank you both. Next will be Taylor Wesson.
Medical reset.
Okay.
I believe Your Honor already found.
I did. Anthony Malone.
Medical reset.
Okay, and I did make a finding of PC in his case. Xavier Maycox.
Main jail.
He's approaching Judge Main.
Thank you. All right. Good morning, Mr. Maycox.
Morning, Your Honor.
You're before the court this morning on 3 charges. Count 1, resisting an officer obstructing without violence. 2, trespassing on an unoccupied structure or conveyance. 3 is a felony probation violation which has a no bond hold. I find probable cause. In light of the no bond hold, do the parties wish to be heard on count 1?
No, Judge.
Yes, Judge. Count 3, I believe, is a felony VOP from Dade County.
Oh,
So we're requesting on count 1, the court consider an ROR on count 1 alone.
I'm fine with that as long as Mr. Maycox understands. I don't know if it's been fully explained to him that, what that ROR is going to entail. That this is on the 94806, Sheila? Okay, so there's not a warrant, so it's not like Dade County's going to be here tomorrow to take him back. It could be some time. I don't know how much, but it could be some time. He's not getting gain time either. And depending on how long they hold him in Dade, if he gets a court appearance on these local misdemeanors and he's still in Dade County, he's still going to get a warrant issued for his arrest.
Judge, we're requesting an ROR.
All right. As long as Mr. Maycox understands all that, I will grant the request. He'll be ROR'd on count 1, and his probation officer will be notified in Dade. Good luck, Mr. Maycox. Jabari Days. Okay.
He's approaching, Judge.
Thank you. Good morning, Mr. Days. Mr. Days, you're before the court this morning on 2 charges. Count 1, burglary with assault or battery. Count 2, robbery without a firearm or weapon. I find probable cause, and I'll hear from the parties.
Yeah, thank you, Your Honor. And I appreciate the court allowing me to reset this for 24 hours. I provided, Your Honor, Mr. Miller with the supplemental report.
Yes.
Authored by Detective Barbeau, and he was, Brandau, and he was the detective involved in this case. I am going to be seeking a finding of proof evident or presumption grade on count 1 and ask that Mr. Days be held no bond. The victim, I can advise the court the victim has safety concerns. He met with Detective Brandau yesterday. I would note that the elements are, the allegations satisfy the elements of the offense. There is independent evidence other than just the victim's word of this incident. Mr. Days was found in possession of the victim's cell phone that he alleged was stolen. Law enforcement corroborated that it was his phone through investigative means and also from the victim identifying it himself. Additionally, there's physical evidence corroborating his allegations. The allegations he made about how the phone was taken from him, that it was ripped from his shirt. Detective Brandau, or law enforcement, had an opportunity to see the shirt, confirm that it was ripped, Your Honor. So relying upon the entire report, plus the first PC, I would be asking the court to make that finding.
Judge, other than objecting to the court finding proof evident presumption great based solely on a hearsay document, I have nothing to add to the conversation. We will reserve our argument for another day.
I've reviewed the probable cause affidavit, including the supplemental report provided today, which does include the information that Mr. Linder has referenced. Based on the information that has been provided, the court will make a preliminary finding of proof evident presumption great in order that Mr. Days be held no bond as to count 1. That will be without prejudice for him to have the appropriate Arthur hearing before his division judge. There's going to be an order of no victim contact, but first let me hear the recommendation on count 2.
Requesting a $7,500 bond on count 2, Judge.
Any objection?
Judge, if the court's gonna be holding Mr. Day's no bond at this time, we defer, to Mr. Day, some sort of relief in front of his division judge.
Okay, that's fine. Then the bond will be set on count 2 at $7,500. And there will be an order of no victim contact, as well as a no return order. Mr. Days, so that you understand the no victim contact and no return order, that means that you're not to return to the location this allegedly occurred at. With respect to the no victim contact order, that means you are not to be in the same place at the same time as the alleged victim. That order includes no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that, sir?
Yes, ma'am.
Thank you very much. Good luck to you. Harry Palmer.
Medical reset.
All right.
Judge, I can't ask for presumption great. Even if everything else here is true, I can't.
Lionel Pratt.
Judge, he's at Conti. With the court's permission, I'd like to waive his presence for the purposes of this hearing.
Okay.
He's set for arraignment on next Tuesday, so we have no objection to the court finding probable cause and ask the court to keep the bond as set.
All right. Any objection to that from the state?
None, Judge.
All right, then I will make a probable cause finding in absentia, and I'll leave the standard bond at $1,000. All right, that brings us to the end of our morning docket, so I'll see everyone back here at 1 o'clock for the afternoon.
Thank you, Judge. Enjoy your lunch.